It was January 31st when Governor Tim Walz signed into law the Protect Reproductive Options Act, also known as the PRO Act. The law codifies the Minnesota Supreme Court's ruling that guarantees the right to the full spectrum of reproductive care in the state. But laws have been passed over the years that would limit options, and although those laws may not be currently enforced, Senator Erin May Quaid would like to see them repealed. She joins me now to talk more about it. Welcome.
Thank you so much for having me.
Last July, a Ramsey County District Court judge ruled that many of Minnesota's abortion restriction statutes are unconstitutional, including the 24-hour waiting period, parental notification for people under 18 seeking an abortion, and the information that physicians were required to provide to patients. Why is it important to repeal these laws?
I think a really good example of that would be our friends and neighbors to the east, Wisconsin. They have an abortion law that bans all abortions from, I believe, 1849, so before women had the right to vote. That is currently in effect. It's banning abortion. And so we know that until we repeal these laws, a future court could come in and do something different. And we know that if we've passed the PRO Act and we've said that every Minnesotan has the right to make their own reproductive health options, then we need to remove the laws that would get in the way of that.
Regarding laws that some might consider archaic are laws against oral sex, anal sex, premarital sex, and adultery. This bill is primarily focused on repealing abortion restrictions, so why include these?
That's a great question. So I think it's really important to know that every single abortion restriction that has been passed by this state legislature has been struck down as unconstitutional either in 1976, in 1995, or in 2022. And so when we were looking at putting this bill together, we were really putting together a list of unconstitutional laws. And the sodomy, fornication, adultery ones are also unconstitutional. And we thought, why not throw them in? They deal with bodily autonomy, they deal with agency, and let's get this done.
The bill would also repeal the annual report that is currently compiled and published by the Commissioner of Health. The report details a number of data points of those who seek abortion care in Minnesota. Why would you like to see this reporting requirement come to an end?
I really appreciate you asking that question. I think the most important thing to know is that this was not put into place, the reporting requirements were not put into place to provide information to the state to do anything with. It was put into place so that they could provide a criminal felony penalty to providers for not collecting this data from their patients and providing it to the state. So the anti-abortion movement has worked for a very long time to put providers in jail, to threaten them with felony penalties for providing safe, legal care to their patients. And so this was just another tool in that toolbox to criminalize providers and ultimately chill the desire to provide this incredibly basic reproductive health care. And so if you are looking at a felony penalty for not reporting to the state government how many children your patient has, would you want to provide abortion care? And the answer is probably no. And so it was a tool of the anti-abortion movement to criminalize providers and break down trust between patients and providers too, because the amount of information they're collecting is extensive and completely unrelated to abortion care. How much money do you make? How much education have you had? Your marital status, how many children you've had, or how many miscarriages you've had. All of that information has no relevance whatsoever to the procedure you're getting or to the provider who's providing it to you. There is no law that would prohibit public health data from being collected from abortion providers and abortion care patients, and all of the important things that we would need to know about abortion care for public health reasons would still be collected. It just wouldn't be required to be collected from providers under threat of felony and misdemeanor penalties from their patients.
So you're saying that the impetus for the law was more about getting after the providers and not about having demographics on people receiving care. So this also previews a little bit my next question, because in various committees you have repeatedly cited the statistic that 2/3 of people seeking abortion are already parents. So without the reporting requirement that we've just talked about, and maybe that's not where that statistic comes from, but would that be a known fact? Are there important pieces of information that could be lost, or would public health officials still be able to garner that kind of information in another way?
The latter. They would still be able to garner that information in another way. It's important to know that, so for example, I know that the maternal mortality has gone up 60% in the United States in the last 2 years, and it's particularly bad for Black and Indigenous mothers. I know that not because we collect a report and publish it from the state under threat of felony penalties for people who deliver babies, but because that is public health data that is collected. And similarly, we could still collect data about people who have abortions, people who provide abortions for use in public data. The other part is that it's always been the case that about 2/3 of people who have abortions are parents. The statistic could go anywhere from like 63% to 67%. And so that is maybe the statistic that I wouldn't have specific to Minnesota year over year, but about 2/3 is probably what it's going to remain for the foreseeable, well, I don't want to say for the foreseeable future because abortion has been banned in so many states that we're going to start seeing some really, we are seeing a public health crisis amongst us right now.
The bill would also repeal the section of law that deals with the treatment of infants born alive after an abortion procedure. Why should this be removed?
That's a really good question. There's been a lot of misinformation shared about this. So it's important to start with the fact that abortion is the termination of a pregnancy for whatever reason. Abortions that happen later in pregnancy are actually, in some complex medical cases, or especially if you're very far along in pregnancy, it's actually just the induction of labor. And so families, the incredibly rare circumstances that these families find themselves in is they, go in, they have an epidural, they induce labor, and they choose to hold their children before they pass away from lethal fetal anomalies or whatever. There's medically complex scenarios. And so what this law does not change the way in which people are treated in that situation. What it does require is providers to provide the intimate details, the APGAR scores of these infants and the specific things that the parents decided to do, whether it was comfort care or perinatal hospice or all of these things, in a report. There's between 0 and 3 families a year who find themselves in these situations, and then we have published their incredibly harrowing, vulnerable details in a public report. So it is not needed. The standard of care for patients, for babies, always remains, right? The people who provide abortion care are the same people who provide labor and delivery. They're the same people. And there's nothing that people who help people have babies want more than to see healthy pregnancies, arrive at a healthy birth. That's just not the case for every family. And it's actually, what this law was also intended to do was to bolster false claims that the anti-abortion movement has made over decades of a thing that, so they created a definition of a thing that doesn't happen, and then they created a law about that thing, and then put in a definition of a thing that does happen so that they can point to a report and say, look, people are having abortions, but they survive. And ignoring the fact that if a child is born alive from a termination of a pregnancy, it's the induction of labor for a complex medical reason, usually for a lethal fetal anomaly, and usually so those parents can hold that child alive before it passes away.
2 other items to be repealed are the requirement that abortions be performed by physicians and the requirement that facilities be regulated by the Department of Health. What's the rationale for these changes?
And so both of those provisions have already been struck down as unconstitutional. So they're not things that are currently happening in the state of Minnesota. Taking the physician-only part, so abortion care is incredibly safe. It is safer than having a tooth extracted. It's safer than having a colonoscopy. Medication abortion is safer than over-the-counter Tylenol or Viagra. And so the anti-abortion movement has really worked to say only medical doctors can provide abortion care when it's actually within the scope of nurse midwives and nurse practitioners and a whole host of medical providers. And in other states, they do provide that care, especially when it involves dispensing 2 pills. That is something a physician's assistant can do and a DO can do. And so it really was just meant to limit the pool of people who can provide abortion care, treat abortion care differently than all other health care, put felony penalties over their heads, right? And so when you do all of those things, you have fewer and fewer and fewer people. Because the goal is to ban abortion for the anti-abortion movement and make it completely out of reach of anybody. And so the reason to repeal that law is because A, it's unconstitutional, B, it harms patients and providers, and C, the more people that can provide reproductive health care, the better.
And finally, briefly before we have to go, opponents of the bill are saying it's extreme. They're saying that some of these laws are meant to protect women or protect the unborn, that there need to be guardrails. How do you respond?
The first thing I'll say is pregnant people are the guardrails. To assert that pregnant people don't know their bodies and their lives and can't make decisions in consultation with their doctors is quite frankly offensive. But what is extreme is using the government to force people to give birth, to try to legislate specific medical procedures in circumstances that they have no idea about. That is incredibly extreme. Making sure that we restore abortion care to being treated like all other health care is exactly what we should do in Minnesota.
Senator Erin May Quaid, I want to thank you so much for your time today.
Thank you.